Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. Trying out our new night shoot. Normally, I'm using natural sunlight coming through the big windows here in the Carbon Club. We're going to try a little something different tonight. Hope it works out. Listen, this is for all of my very loyal followers in Illinois. I know that you guys are having a rough day today. You think that the world has come to an end. And candidly, most days when you're in Illinois, I understand why you think that the world might be coming to an end. And yes, there is more bad news today. And let's face it, Illinois, if you didn't have any bad news, you guys wouldn't have any news at all. But as we know, after last week, when the 7th Circuit en banc panel said, you know what, we don't really need to hear anything else in Bevis v. Naperville, our last hope was that Justice Coney Barrett, who had received an application for an emergency review, would step in and do something about it. However, we found out today that, well, that's not going to happen. Now, I know that has Illinois screaming victory and many of you wanting to throw yourself off a bridge, but time out, let's hold up. I'm going to show you why this might actually work out for the best, and there's a reason for it. So today, let's spend a few minutes and let's talk about, don't freak out, Illinois, there's a long way to go. Okay, case we're talking about again today, Illinois. It is, by the way, almost 6 o'clock in the evening here, and when you live in Seattle, this time of the year, obviously at about 3:30, we're already in the dark. So we're trying here from Security Gun Club in the evening. The case we're talking about is Bevis v. Naperville. We have talked about this case a lot. This is a challenge to technically the city of Naperville's assault weapon ban. It's almost as bad as the one being challenged in Calkins v. Pritzker because it doesn't include the actual gun registry that the statewide ban does. This case had been appealed into the 7th Circuit to a 3-judge panel who found absolutely no constitutional deficiency with that ban whatsoever. National Association for Gun Rights who's representing Rob Bevis on this, then had appealed both to a full en banc panel of the 7th Circuit, who also wiped their rear with that petition. And there had been a petition to Justice Coney Barrett, who, as we know, sits on top of the 7th Circuit. And we were hopeful, very hopeful, that in fact she would do something about it. She has not. Now, what that means is that this case is officially done, okay? But it's not. Because as you know, one of the things that the state of Illinois and the city of Naperville was screaming bloody murder about to Justice Coney Barrett was, hey, it is incredibly rare for the United States Supreme Court to accept a case on an interlocutory basis. What do I mean by that? Jumping into the middle of the case. No, you're right. It is true that the United States Supreme Court actually likes to wait for everything to be to completion and then review the matter. So, had Justice Coney Barrett taken it, which I know a lot of you were hopeful, I was hopeful as well, but it would have been a rather extreme measure for the court to do so. But now at this point, this case is final, which means that Rob Bevis and the National Association for Gun Rights gets to petition to the United States Supreme Court the old-fashioned way, a writ of certiorari to the United States Supreme Court. This is the way that almost every single case gets to the United States Supreme Court. And so what Justice Coney Barrett did by terminating this interlocutory review is finalize this case so that the plaintiffs now can come on board in a normal fashion. I have no doubt, even though I am not operating on inside information here, but I have no doubt that the attorneys over at the National Association for Gun Rights who are representing Mr. Bevis will likely have that petition for certiorari filed in the next few days. So, Illinois, is it a setback? Yes. But, let's face it, we're all getting used to setbacks right now. But there is an opportunity here, and it is an opportunity to actually get this case, and in a perfect world, this would allow the Calkins case to get consolidated with the Bevis case and get it both before the United States Supreme Court on a petition for argument next term. The case, once again, everyone, is Bevis v. Naperville. We'll go ahead and link up the Supreme Court docket. You can see the tiny little entry, which basically that ends it here. If you got any other questions about that or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information's down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.